Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is May 14th, 2020. This is our bi-weekly community conference call. It is not meant to establish attorney-client relationship or give you specific advice. That said, you've heard the disclaimers when you logged in. Let me get started on the frequently asked questions first. And these are all unique circumstances because of the COVID situation. Ravi Ganesh wanted to know, I'm on an H-1B visa, came to India, and now I'm stuck here. I've got the visa stamping. Do I need to file a new H-1B? And the answer is no. No. Remember, on an H-1B, you can be outside USA after getting stamping or whatever you've done for a very long period of time. The longest I have had a personal case is about 2.5 years. So the guy was outside USA after getting an H-1B for 2.5 years. The only requirement is that the job must be available when they are returning. So we were able to show that he was working on the project while he was in India and that he was going to continue the same project and the job was still available to him. So that's not a problem. Okay, you don't have to apply again. You are safe till the end of your H-1B approved period. Continuing with the COVID facts, I've got a bunch of questions here. First one, I'm not sure who it is from. Sorry, guys, I kind of lose track of that. The question is, I'm on H-1B, I got laid off. I've got my paid time leave, and I got a COBRA for health insurance. So COBRA is usually given at termination. I'm not sure how that works. So how would I know if my employer has canceled my visa? And I've dealt with this issue several times in various conferences. I will repeat it again. In order to legally revoke an H-1B, an employer must do at least 3 things. There are more, but 3 they must do, without which the employer is not considered to have terminated your services. That means if they don't do all 3 things, they continue to be liable to you for their full salary. Because the salary obligation only ends when they terminate your services. But if they don't do these 3 things, all of them, they have not terminated your services. What are the 3 things? First, they must tell you you're fired. They have to tell you that. They can't leave you in suspense. Second, they must offer you a one-way ticket back to your home country. And the third, they must tell USCIS that they are revoking the petition. Unless they do all 3 things, you're not fired. But let's look at the practicality of the first 2 items. First item, they must tell you you're fired. What if the employer says, oh, I told him, and you say no? In my view, you are likely to be winning that argument because the employer should give you something in writing. That is the smart thing to do. And if they don't, then in a wage and hour division investigation, the officers who come to investigate the non-payment of H-1B wages are probably always going to find for you. They don't find for an employer in these cases. So chances are, if the employer has not documented all 3 things, they could end up paying back wages for the entire duration until your H-1B expires or until they do all the 3 things. So the first thing, you are fired. If they haven't put it in writing and you don't know if you've been fired, it's your word against theirs, and your word is likely to prevail. Number 2, they must offer you a one-way ticket back to your home country. And again, smart employers document that. If you say they never offered me and the employer says I offered you one-way ticket back, the Department of Labor is going to believe your word almost always. And I have been through over 164, 5 of these, different kind of, different kind of investigation and audits, I can tell you that the wage and hour division is quite tough on employers who don't pay full salaries, and there is no excuse. There is no middle way. They either have to pay you or let you go. In many ways, it gives you extra protection more than what your American counterpart workers would have. American workers, they can let go. But H-1B rules require a certain choreography before they can let you go. So 3 things: tell you you're fired, offer you one-way ticket back home, and revoke your case. Okay? The next question, so when does my 60-day grace period begin? Of course, it never begins if you've not been fired. Can you file a B1, B2 before those 60 days? Yes, you can. Yes, you can. The only problem is the moment your B1, B2 is approved, then you no longer have the right to receive your wages. Okay? And I'm going to come to follow-up questions on this. Let me finish all the questions in this series. From Rahul Gopal Joshi, so I'm working from home, right? Employer's office is not officially closed. Non-essential staff is recommended for working from home as much as possible. Home address is in the same metro statistical area as the work location. So when should I do an H-1B amendment? This is my take, folks. I've dealt with it many times. I'll do it again. First of all, there are 2 agencies involved, U.S. Department of Labor and USCIS, and they can have slightly different rules about what you should be doing. Whenever you have a new work location within the same metropolitan statistical area or within approximately 50 miles from an approved LCA location, you should not have to do an H-1B amendment if the job description is the same. So if I am in, let's say, living in, to give an example of DC area, my job is in DC, but I live 30 miles away in Virginia or in Maryland, I'm covered by the same metro area and I am within 50 miles. Either one is okay. So I really don't have to do an H-1B amendment if I want to work from home. Do I have to do an LCA? And this is where there's a split. Some lawyers will tell you, you should do an LCA amendment to include your home. It's not a big deal. Doing a new LCA doesn't require going back to the USCIS. If you can conveniently, do it. If you cannot, we have had Department of Labor give their opinion in conferences with immigration lawyers that they don't enforce home-based LCAs. Why? Because the LCA will be posted in your home. That's a silly thing to do. The purpose of an LCA posting is to inform the workforce who works on the premises that the employer has hired an H-1B worker, and if you, Mr. American worker, have any problem with it, complain to the Department of Labor. What is the point of posting that at home? So personally, I am okay if you don't do an LCA amendment or a new LCA posting, but if it is not inconvenient, why not? Okay. Does an LCA amendment also mean H-1B amendment? No, not at all. An H-1B amendment is a pain in the behind. An LCA amendment or a new LCA is quite easy. If no LCA H-1B amendments are needed, are there any other things needed? No, I don't think so. I think you're compliant. Now, it becomes more tricky if you are outside that area. Do you still have to do an LCA? In that case, I would have to actually not only consider an LCA, but even an H-1B amendment. Because if you are, think about the logic. An LCA makes sure that you're getting paid the right amount of money. So what if you work in a little village in Pennsylvania, but you live in Manhattan? Manhattan salaries are going to be 3 times larger. So if you are working in Pennsylvania, your H-1B is approved for small town Pennsylvania, but you are living in Manhattan, and if you start working from Manhattan, we expect you to be paid the Manhattan salaries. Now you have to do an H-1B amendment. So if you are living beyond approximately 50 miles or outside a metro area, you would probably have to do an amendment to cover your home. An H-1B amendment, which means going through the USCIS. Questions on H-1B extension. Same employer, no change or extension pending, possible travel to India, and re-entry before the current H-1B expires. Sure, why not? You can definitely travel. Only thing is you need an H-1B visa, and make sure when you do come back, you have evidence, including a letter from the employer verifying that you have an H-1B job still available. Certainly allowed. H-1B extension paperwork submitted even during extension or transfer. You can travel and re-enter during the life of the first H-1B visa stamp. If you don't have a visa stamp, then you have to wait until your case is approved, get a visa stamp, and come back. And don't worry about reconciling the I-94 number. That's not relevant. And there is no last action rule as long as you enter before your H-1 extension or transfer is approved. I don't think you need to travel outside USA again. Next question is, I have an LCA address as my home address. I'm just moving apartments. And the answer is the same. First of all, you definitely do not need an H-1B amendment. You should do an AR11 update. And if you want to be extra careful, either do a new LCA or just a new posting in the new apartment. Again, I think it's silly. I don't think it's necessary, but it's up to you. Monica posted a community member's question they were not able to post. So currently I'm working for a client A based in San Francisco. Company filed for an H-1B extension using client's A's project and location. If I move to another project with client B, which is also in San Francisco area within 50 miles, do I need to file an H-1B amendment as there will be a material change such as project name, client name? In my view, every time a client changes, a job description changes, or perhaps even a project changes, if you're working at an end client project, I think you would require an H-1B amendment. There is a decision called Matter of Simeo where the government gave us an incomplete statement of the law. They said you don't need an amendment if you get moved within the same area. But what they did not say, as long as everything else about the job remains the same. So if you change clients, this is the way I see it. If you change clients within the same building, I think you need an H-1B amendment. That's my opinion. To me, it's a substantial change. Okay. So if you change clients, my view is you need an H-1B amendment. There are lawyers who will tell you under Matter of Simeo, you do not. I don't think Matter of Simeo is properly completed. It just reflects one particular aspect of this problem. Regulations are very clear. Any material change requires an amendment, and a change of client, change of project, change of location are all material changes in my view. When I start working from home with client B, and again, I've covered this, that if you are working from home and your home is within the same geographical area, maybe an LCA is not required, but if you want to, you can do it. An H-1B amendment is definitely not required. But if you are beyond normal commuting distance of an approved location, then you probably will have to do an H-1B amendment as well. If your home is 70 miles away or outside the metro area, you probably will have to do an H-1B amendment. Okay? So I've answered all questions that I considered to be COVID related. Guys, if you have any questions about anything I discussed, nothing new, but anything I discussed, press *5. Press *5 on your phone so we can deal with them. Okay, this one is from Wisconsin, and it looks like there is only one question. Wisconsin, go ahead, please.
Hello.
Yes, go ahead, sir.
Yeah, Namaste Rajiv sir. We have met before.
We
So
have.
I'm the one who asked that LCA and H1B travel question.
Acha ji.
First of all, I hope all of you are safe and stay safe, stay healthy. Uh,
Absolutely. Yeah, thank you,
the
sir.
reason, so now I'm talking about, thank you, sir. So Abhi, I'm talking about that extension thing, and travel. So it's the same
Okay,
employer, there is
right.
no change of employer. But normally when you submit the extension, I'll submit it with my current I-94.
Yeah,
But
hang on
when
one
I
second. Hang
re-enter
on one
and
second.
within my
Hang
current,
on, sir. Get off the I-94 kick. It doesn't matter. That's not an issue. Even a changed I-94 number does not affect you. Okay, so if you
do I
enter
have to
USA,
notify USCIS
hang on,
that?
hang on. If you enter USA
Uh-huh.
today and your H1B gets approved tomorrow, it's tomorrow's I-94 that comes with the approval that matters. But if you enter USA um,
Yeah.
after your H1B gets approved, you'll have to renew your I-94. I think it's a silly rule, but government wants you to
Right.
go and get the H1B extended, so you just have to step out and step back into USA. So the answer is H1B number is irrelevant. Just make sure you enter USA before your H1B gets approved.
Okay. Okay. ठीक है. The reason I'm asking that is someone told me that you have to notify USCIS
Okay, no, no, no.
about your new I-94 number.
I'm not going to respond to that because people will say all sorts of things. Don't worry about it. Okay, you don't have to
Okay.
inform anyone.
Okay. Okay.
It's
Thank you.
quite clear. Okay.
Okay.
Yeah,
Okay.
very few things in law are
Okay.
clear,
Thank
but
you, sir. I will do that.
this one is actually in writing from the government somewhere. Okay.
Okay.
Good
Okay.
luck.
Good.
Okay, so let's go on to the next frequently asked question. And this one I've answered in detail. If you go to my LinkedIn page, you will see that I have a discussion of this back from like 3 years ago. Can an H1B start their own business or invest? And I'll revisit this even though I've done this many times. And I've said, look, there is nothing that's really written down by the government specifically addressing this issue. But using our common sense, our knowledge of law, our experience with the law, in my view, this is my opinion, if you are a passive investor, which means you do nothing to earn the money, any activity you do is not related to preserving, continuing the business entity, or making money, you are okay even though you are an H1B. So, for example, if you are an H1B, can you buy IBM stock? Why not? Can you buy Microsoft stock? Why not? You don't, just because you bought some stock doesn't give you the right or the obligation to run Microsoft or to run IBM. It's just a passive investment. I don't see any problem with that. What would be a little bit more troubling would be, what if you became a day trader? Would that be allowed? I'm not so sure about that. That becomes closer to active investing. Now you are not really investing and letting the money lie there. You are moving money from stock to stock, and the activity that creates the money is the movement. That's my interpretation, and I hope that government comes back and says, no, Rajiv, you're wrong, and I'll be happy to be wrong. But that's my understanding. So let's look at the questions. Adi says, can an H1B holder earn passive income other than real estate and stocks, being a passive shareholder S Corp? Yeah, why not? Why not? It's just that make sure that you stay passive. Can an H4EAD open an S Corp? Oh, absolutely. See, I was just talking about this with somebody. I did a consultation today. An H4EAD has a lot many more rights than an H1B holder. How? H4EAD can choose not to work. H4EAD can choose to work for 10 employers. H4EAD can choose to work in any field, not in just their own degree field. H1B can start their own business. H1B can also, what did I not cover? So an H1B can functionally do everything that a green card holder can do. So in that way, their rights are far larger and greater than the H1B holders. Can an H-1B holder be an active partner without salary? Now, this is where I start getting a little nervous. Why? Because I'm actually in the middle of a discussion with a university, and I think I might end up suing the university because they're screwing up the career of a young student. What they did was, they told this young student, they told her, well, you have interned for XYZ organization, and therefore that's a violation of your student status. So not tomorrow, May 15th, we are going to cancel your service. And I just sent them an email. I said, I've looked at the regulations, I've looked at the case law, and it's very clear. If you work without getting paid, without remuneration, it should not be considered unauthorized employment. So if a student volunteered her time, she did not get a single penny out of it, I don't see how it is a violation of her F1 status. Okay, so I told her, I said, if you're going to violate her out, then I want you to pass my email on to your university counsel so I can let them know that, well, I don't want to name you as a defendant. If there is a regulation that's creating a problem, we'll sue the government in Washington, D.C. But if you are doing something, then I have no choice but to include you as a defendant in the case. So the point is that working without getting paid is probably okay. But remember, under Fair Labor Standards Act, for-profit companies are not allowed to take free work. Again, if you look at this, I have an article from like 5 or 6 years ago on my LinkedIn account. I don't have it in my blog, and we're actually working on redoing some of the content on our website and coordinating better between social media and our own website. What happens is I end up spending a lot of, I spread a lot of information over various media, LinkedIn, Twitter, used to be Google also, not anymore, Facebook. So I do on various media, and sometimes I don't keep it all together in one place. Wherever I am, I happen to see something I want to comment on, I do it. So the point is that if you're not getting paid, it's probably not a violation of immigration law, but it is probably a violation of Fair Labor Standards Act, and I'm not an expert in FLSA. On top of that, the law says remuneration. The word remuneration may not mean necessarily just money. What if with your activity, you are creating larger value in the corporation? Ultimately, that's a form of payment. So I think activity of any kind, unpaid or paid, might be objectionable and might convert you from passive to active investor. Rajesh Reddy had a series of questions. Can I start a YouTube channel on H-1B? Can I earn income through it? I think it's closer to being active. Can I put the money in my Indian bank account? I don't think that makes a difference. I think that could be construed by the government as unauthorized employment. I'm not sure. There's no law on this that I know of, other than what I just cited to you. *5. If you have any follow-up questions on this, press *5. Okay, you have 2 questions, and I don't know where you guys are from. Area code 347. Where are you calling from?
Yeah, Rajiv, I'm calling from New York.
Yes,
I have a question on CPT actually. It's
no,
related
hang
to
on.
what you explained just now.
Don't mess up my call. Don't mess up my call, because I'm in the middle of answering a question and you're asking an unrelated question. Wait for your turn, please.
Okay.
No, don't mess up my call.
Okay.
Okay. Area code. Yeah. Let's see. Oh, I think I messed up. Hang on 1 second. Let's see. So New York is gonna wait for their turn. Who else had their hand up? I'm sorry, I put it down. Press *5. Okay, here we go. This is area code 424. 424, where are you calling from?
Hi, Rajivji. This is Rajesh from California.
Rajesh Reddy, how are you, sir?
Good. How are you?
Good.
So I had this question about YouTube. So what if we use this time until our
until my priority date becomes current to just gain the audience in YouTube. Would that be
I
enough?
think that would be okay. You know, I have a YouTube
Okay.
channel where I teach how to play flute. Okay. So I have
Okay.
about, I think, 35,000 followers, but they insist, see, if I want to have unlimited recording time, I have to monetize videos. So what I do is I monetize only 1 or 2 videos so that the money coming in, I'd never see any money. I have never seen a dollar coming from YouTube. So I guess what you could do is marginally monetize and build audience. I don't see any problem with that because you won't see any money coming into you.
Okay.
So monetize the minimum amount of videos that you can, just 1. And then you are a partner with YouTube and you can do a lot more like I can. So it's interesting that my flute videos have 30,000 plus people, but our office video has about 1,000 plus people following. So, I could be making a lot of money if I wanted to, but that's silly. That's not why I do it. So I had to monetize 1 video, but I didn't have to. Oh, actually, they let you know that you have to monetize more videos because they also want to make money from your channel. So monetize the least amount, and I think you'll be okay.
Yeah, because my priority date is like Feb 2015, so it's like long way to go.
Yeah, I don't see any problem with building an audience. What's wrong with that?
Yeah. But you're saying like if you use an Indian bank account and monetize a lot of videos, then it's a problem.
I think so too. Actually, I'm kind of contradicting myself in some ways because if you think about it, somebody asked me the same question. What if I work for my company without getting paid? How is that different from creating an audience of your YouTube channel? I just think it's a little different because YouTube can be for personal reasons too, right? So
yeah,
I don't know. I mean, I think these are difficult calls to make, but one easy thing to remember is if you don't see a dollar, you don't have to worry about it.
Okay, so the best other option is to not monetize the videos quickly, build the audience, and once your adjustment status comes, like 485, and then you can start monetizing.
There you go, Rajesh, because then it's just a personal hobby. It's not for money.
Okay, got it. Sounds good. Thank you so much.
Oh, you're welcome. Okay, so I have one more question, I think. Let's see. This one is from area code 817. 817, where are you calling from?
Yeah, hi Rajiv. I'm calling from California, but this is a Texas number.
I see.
This is the one I sent email to Monica.
Okay. Yeah, I remember. I got your email too.
Yeah, thank you, Rajiv. Thanks for that accommodating last minute my question.
But hang on. Well, that was from the previous questions. Okay. I'll go back to your previous questions. Go ahead. What is your question?
That was the last question that was posted in your forum. This is regarding the changing from client A to client B.
Oh, hang on 1 second.
So
I thought I covered it. Give me 1 second.
Okay.
Currently, I'm working for a client A.
Yes,
which
you
is
did. I have followed.
San Francisco, California. Oh, yeah. I talked about matter of Simeo. Yes, go ahead. So what is the follow-up question?
Follow-up question is that I heard that within 50 miles, there is 50-mile radius of MCA. There is no, for that, if the new client is 15-mile radius of the MCA,
I disagree.
There is no LCA required.
I disagree.
Okay.
I disagree because, I said that, and I don't know if you heard me. What I said was, the matter of Simeo statement of law is incomplete. Okay, so I'll tell you the rule in my office is.
I'm sorry. How do you? I'm sorry. How do you say Metro Simeo?
Matter of Simeo. Simeo was the company.
Oh, matter of
SIMEIO.
Okay.
And you can actually Google it. It comes up. So in the matter of Simeo decision, the government basically took that ruling and expanded it, basically saying that you don't need an LCA for movement or don't need an H-1B amendment. LCA posting you need for sure. LCA maybe not, but H-1B amendment definitely not if the job remains substantially the same. Okay. Now here that's where the problem comes in. What is substantially the same? I think if the client changes, it's not substantially the same. Okay, now I'll tell you something though.
Okay. Yeah.
I'll tell you something though. Because they have given you an incomplete statement of law, you could be aggressive about it and say, hey, that's what you said in matter of Simeo. Don't come after me now. But all the good lawyers, the smart lawyers will tell you, smart thing to do an H-1B amendment for these cases. Okay.
Yeah, Rajivji, because that's what my confusion is, because the new clients will have the same job description.
Look, I would like to, but I can't give you the answer you want. I can only give you the answer I think is the right answer.
Okay. And then one last question is, where can I find any documentation about this matter of Samir
You
rule?
can just Google it or whatever searching. I have stock in Google, but I have no interest in which engine you use. Use any search engine and just type matter of Simeo. It comes up.
Yeah, sure, I got it. But I was just wondering, like, if there's any documentation on USCIS site where I can.
Yeah, actually, you know how to do a site restricted Google search, right? You go USCIS. You go matter of Simeo space site : without space .gov or USCIS.gov. It pulls up the information.
Okay, but basically this rule comes from USCIS or
it comes from
DHS,
USCIS.
Rajivji?
It's a combination of two things. Under 8 CFR 214.2, Code of Federal Regulations, Volume 8, Regulation number 214.2, which is also available online. Under subsection H, it will tell you that you need an H-1B amendment every time there's a substantial change in the job. Okay. So matter of Simeo addresses only one aspect of the substantial change, geographical movement. It does not address change of clients. It does not address anything other than just the geographical location. In my view, change of clients means an amendment. Okay?
Okay. So when when they said geographical movement means the same client is moving to different buildings.
Oh yes.
Okay, got it. Okay, thank you.
That's the easy
thank you
one.
So much.
Same client moves within 45 miles. Don't have to do an amendment, just an LCA posting. Okay?
Oh, okay.
Good luck.
So thank you so much.
Oh, you're welcome.
I appreciate it.
You're welcome. Okay. So we did the H-1B start your own business. Promotion after getting the green card. So this is a situation where Mr. Suresh, and congratulations, you got a promotion, says I got a green card as a software programmer, and just or just a couple of months ago, 2-3 months ago now, can I become a manager? And I don't see why not. You've been working in different software programmer positions and planning to. I've been in the software architect role for at least 4 years, and the 45J was also filed. Good. So personally, I don't think it's a problem. I think you are covered from two angles. One, once you get your green card, you're not to be a slave to your job. And two, even under AC-21, American Competitiveness in the 21st Century Act, you're allowed to take promotions. You already did. You went from programmer to architect. Why can't you go from architect to manager? I personally don't see any problem with it. *5 if you have a follow-up question. *5. Okay. So let's see. This one is, I don't know where it is from. Area code 515. Where are you calling from?
Hello, sir. This is Suresh. I'm calling from Iowa.
Okay, Sureshji, go ahead.
Sir, thanks for that response. My question was basically the intent of the employment-based green card.
But hang on. If you talk about the intent, how did you go with a 45J from a programmer to an architect? Doesn't that bother your intent?
That is correct.
So
yes,
the idea is
Yep.
AC-21 has diluted this intent nonsense. See, remember, when the green card program was initiated, when I got my green card, it took me 6 months for the entire process. Labor certification, I-140, 485. That's what it was supposed to be. It wasn't supposed to be 14 years.
Exactly.
So don't worry about it. If they bother you, that's why the good Lord made the courts.
Sir, one final question. Does it matter moving from a technical responsibilities to more managerial responsibilities or anything?
When you say more,
as soon as people start talking about.
When you say more managerial,
yes,
I think you are still fine, because if the job that you went to requires technical education, or is one of the requirements is technical education. So MBA or master's degree in information systems, or master's degree in computer science, or bachelor's degree in software engineering, all of these qualify you for the same job. I think you're okay. So in other words, if the prior job is a qualification for the higher job, I don't see any problem.
So in this, the team that I'm working in, most of the people who are all architects, they are all coming from different backgrounds. Not everyone has masters. So it's expected that the manager is not required to have a degree that matches the members that the manager is going to manage.
It's not required.
Okay. Okay. Cool. Thank you, sir. Thanks a lot.
You're welcome. Okay, so all right. So I think we are covered. Oh, here's another one. Extraordinary Circumstances EAD. So the question is, I'm an Indian national H-1B. I'm in New York City. Oh man. I'm trying to figure out feasibility, risks, and pros and cons of doing I-140 EAD based on compelling circumstances. So what happens with compelling circumstances is, first of all, you have to file for compelling circumstances EAD. Your I-140 is approved, priority date is not current, and you are still in status, which means either working for the employer or within 60 days after getting laid off. You can apply for compelling circumstances. As long as that is pending, you can continue to stay. If you get approved, you don't have status, but you have authorized period of stay. You can continue to work and continue to extend your compelling circumstances EAD. Question is, would it work during COVID times? I think it could. I don't know how the government is going to look at it, but if you go to my blog, I have a write-up on this, and I posted a link at the end. So if you click on this link, it'll bring you here to compelling circumstances EAD. I have done an outline of what the regulations say, and I've done sample cases that we have done so far. We are a little backed up with we'll be posting a lot more. I haven't had time. We've been so busy. But here are the regulations, and I think I did a good job putting a graphical summary of the regulations. You can see the whole thing. Oh, by the way, these used to be thousands of shares, but we had a database crash on the website. We had to rebuild the database from a backup, so we've been kind of bummed out about that. This used to be a very popular, this particular graphic, but it doesn't matter. It's not a popularity contest. You will see if you go to this figure, what is compelling circumstances EAD? How does it work? What are the examples of compelling circumstances? Go take a look. It might be possible to do it. Okay. Let's see. *5 if you have a follow-up question on this, on compelling circumstances EAD. *5. Okay. So this one is coming from area code 646. 646, where are you calling from?
Hi, Rajiv. I'm calling from New York.
Yes, sir.
So there are other two questions that I've asked in this set of questions, basically, right? So, yeah.
Should we be thinking about this? Yeah, I guess so. If I do this and we approved and denied, what would it do to my H-1B? Okay, so if you stay on your H-1B and continue working and try for the compelling circumstances EAD, if it does not get approved, no effect on your H-1B. If it gets approved, your H-1B is out the window. Now you are on compelling circumstances EAD. If you want to convert back to H-1B, you'll have to get an H-1B approved if the old one is gone, and go outside USA, get a visa stamp, and come back. That's all. Okay. So you can always get H-1B renewals. It's not an issue. The only problem is you have to go outside and come back with a visa stamp.
And that would require the lottery process for H-1B.
No, if you have an H-1B already approved, there's no lottery. You're not subject to the lottery. You're just subject to visa stamping.
Got it.
Okay.
Got it. So let's say if I were to get the EAD approved, right? And my H-1B expires next year, and so would my EAD, right? At some point next year.
No,
time of
no,
approval,
you don't
right?
need an H-1B to have an EAD. The compelling circumstances EAD creates a standalone. Are you a software developer?
No.
Okay. Otherwise, I would have given you example from software. But the point is, it creates an isolation chamber in which you are on just EAD. You don't need any other status.
Right.
Okay.
So the risk comes at the end of that EAD.
Yes.
When the time comes to renew that EAD.
Right. Exactly. Okay.
So if I were to neutralize that risk with an extension, and there are some caveats around that extension also, but if that extension comes in risk,
as long as the compelling circumstances continue to exist, you can keep getting extensions. And you know what I tell people? I say, if I get your first extension done, just use the same paperwork. If the circumstances are the same, don't keep coming back to us and keep paying us more money. We are going to use the same paperwork anyway. And if you get into any sort of RFE and all, you can always hire us for that. But don't have to hire us for extensions.
Yeah, so there is subjectivity in here in the choice of whether to do EAD or not, because compelling circumstance for me now would be the COVID situation, right? In a year's time, it's anybody's guess if that compelling circumstance exists.
I think it is
if it doesn't exist.
Yeah, I think it's a compelling circumstance. But if it doesn't exist, they won't give you an extension. You'll have to get into an H-1B situation.
That was my question earlier on to you. Right? So if I were to lose my H-1B status now, and at the end of my EAD, I want to get back onto H-1B because EAD cannot be renewed.
Right. You can.
Reason, right?
You can.
Then is that H-1B, would that require me to get back into the lottery process? Or
no, there's no lottery.
No.
No lottery. Okay. For 6 years, you have no lottery.
Thank you.
Okay.
Yeah, my H-1B is way beyond 6 years.
Yeah. No, the point is, once you've been counted in the lottery, you are blanketly permitted to be outside H-1B for up to 6 years. So let's say
you have to participate in the lottery.
No, let's say you have an H-1B for 2 years, and then you go to India for 5 years. You are still exempt from the lottery if you want to take the remaining 4 years on your H-1B. Okay. Actually, the remainder.
If I have not participated in the lottery.
Yeah. Actually, it's a little bit more complicated. It's a little bit more complicated than that. The example I gave you is called the remainder option, and the remainder option actually has no time limit. You could be outside for 15 years and still come back without the lottery.
I've not participated in any lottery.
Yeah, you don't have a problem.
So I guess I will have to.
You're fine.
Nice.
Okay.
Okay. Cool. Thanks.
You're welcome. Next one is, and this is also a very commonly asked question. I've answered it many times, from Palak Domesia. Mother is visiting. She entered December, I-94 going away in June. Can I extend her visa due to COVID? Why not? How many days before I can apply for extension? They tell you 30 or 60 days ahead of time, but we have done it even 1 day before. So I would say maybe 5-6 weeks ahead. Now may be a good time to apply. What if a visa is not approved before July 11? Because once you file this, and you file this before her current status expires, she's considered to be legally okay to stay while waiting for a decision. And I have a lot of recordings on this. Go back to our frequently questions on immigration.com and listen to the last few weeks' recordings. I've discussed this question over and over and over again. Okay. *5 if you have a follow-up question on this. *5. Okay. And I'm going to make time for you guys. If you have questions, new questions, I'll make sure I answer them. Even though we'll go a little bit beyond my expected time, but that's okay. I just don't want to leave anything unsaid. So let's go back to our other questions, which are not frequently asked. So this is a frequently asked questions. These two we have covered. All of these we have covered. Here's one. Political asylum. I'm so sorry, JJ. I don't know anything about asylums. I have said this many times before. I hate to waste your time. But you're going to have to talk to somebody else who does those. From PO Box 8284555. I had my EB2 interview last month waiting for an update. So what happens if I change my address and the new address is under a different USCIS office? Well, as I understand it, one of the two things. Either the current office, because it's so close to the end, can complete your case even though you have moved out of their jurisdiction, or they can choose to transfer your case. I doubt if they will transfer your case after interview. But if you want to be doubly sure, you can just call USCIS customer service. Okay. Even if you move out of state, it is my understanding the old office can continue to adjudicate your case. *5 if you have a follow-up question. *5. Okay. Next message is a blank. So you got picked up in Lottery Bharat. Now the question is, employer doesn't want to file your H-1B. What do? I don't think you can do anything. I don't think you can take your lottery winning through one employer over to another. That's my understanding. If you are able to do it, power to you. I do not think you can. *5 if you have a follow-up question. So you've got an SD-29, you've got your green card, your visa approved. The government will extend your visa. I don't think it's a problem. Family-based visas, if they're suspended for 60 days and if they expire, you should be able to get them extended. I don't see any problem with that. *5 if you have a follow-up question on this. Okay. SK 2008 went to India in March on EAD-AP. Will the executive order affect me? No, it does not. So you're fine. My I-485 application has been pending since 2012. What if I go beyond 6 months? 6 months is not a problem. No, you're wrong. On advanced parole, you are not confined to a 6-month period. You can stay outside USA as long as your advanced parole is valid. And your job is there, either the same job or similar job under AC-21. So *5 if you have a follow-up question on this. Okay. So next question is from Rick Nim. It's about cap exempt and cap subject. Can candidates start working for cap H1 upon the receipt of the concurrent H1? As far as I know, I'm pretty sure I've seen this. You can double check, your lawyers can double check. So if you're already working on a cap exempt H1B, you can start working for a cap subject H1B as soon as it is filed, not wait for approval. *5 if you have a follow-up question on this. *5. Okay, here's one from area code 908. I know that one. That's New Jersey. New Jersey, go ahead.
Hi, Rajiv. I posted this question on your on message in LinkedIn, and you asked me to post it here.
Yes, sir.
My other question is, I am on a cap subject. I've never been to lottery before.
Okay.
That's one point. The other point is, current employer is furloughing me and I'm only working half part-time in my current job. So they are trying to file my amendment. So should I have to wait till the amendment is
No, I don't think you need to. I don't think you need to wait for an amendment. As long as you're considered to be maintaining status, this is so fuzzy. This is an outlier. It's difficult to give you an exact answer. But the legal answer is, as long as you're maintaining status, you can file a concurrent cap H1B and start working on it. But question is, what is maintaining status if you're in part-time? And if you're in part-time for a very short duration of time, I think that's okay. You should be considered to be maintaining status. But this is a difficult question to answer. Of course, if your amendment is approved, then there is absolutely no doubt that you can start an H-1B concurrent employment for a quota subject employer as soon as it is filed. Okay.
And on the tab subject control H1B, I am going to file. Should I have to mention the hours that I'm working on the
there is no such column in the paperwork that asks you that question, but you can discuss it with your lawyers. It's a very fact-specific issue. Discuss it with your lawyers. They should be able to guide you through this murky area. Okay.
Sure. And is there any link or document that I can refer to about this control H1B if I can start looking at
they should do their own. They should do their own research. Why should you be doing it? I mean, you can look around. I'm sure it's there, but I don't know where it is. I know it is. That's the law. But where it is, I don't know.
Yeah, I was talking to one of the attorney on the client side, and it looks like they have limited knowledge. That's why I'm trying to help them out.
Then they should change their profession, because there's no reason for people not. This is not that difficult an issue. I mean, I can understand if there are certain tertiary issues of law people don't know, but this is a relatively basic issue in the H1B area. You should be able to find this information. I mean, go through the search patterns in Google. You will come to the right place eventually. Sure. It's available on government websites. It's available on private websites. So, okay.
Okay. Good. Thank you.
Good luck. Okay. So, I think we are done with the posted questions. Anyone has any question? Press *5. Okay. Let's see how many we got. 1, 2, 3, 4, 5. Oh my God. Okay. 6, 7, 8. Holy cow. 9. Oh, you guys have a lot of questions. That's okay. Well, all right, let's get started. So, okay, 9 questions, guys. Don't ask me any more after that, okay? That's all we are doing today. 9 questions from 9 different people. Let's get started one by one. This is area code 469. 469, where are you calling from?
Hi, I'm calling from Texas.
Yes, sir. Go ahead.
Yeah, thank you for the call. So, my question is, my employer A filed a H1B extension already, and if I move to a different employer B, or like if I move to a different employer B with H1B transfer, is it mandatory for my employer A to withdraw my H1B extension? Like legally,
no.
He should withdraw the extension?
No, it is not required.
So in case even if the extension of employer A is approved after my H1B transfer completed, okay, I can come back to employer A, right?
You can come back to employer A, and you can also continue working for employer B, because approval of one doesn't overrule the other. They can both live together.
Yeah, so one more thing is, like in the same scenario, my employer A applied H1B extension for client A. In the same scenario, within employer A itself, if I go to a different client B, is it mandatory for my employer to withdraw the previous extension? Like same employer can have 2 extensions parallelly?
Hang on 1 second. Is your previous H1B expired already, or are you still in H1B status?
I'm still in H1B. My I-94 is valid till October 1st.
So
before October 1st,
hang on, stop. Yeah. Look, I have limited time, so you're going to have to be a little quick with me. We can't just dawdle. Bottom line is, if your existing H1B is still valid, they can file as many extensions and amendments as they want. There is no problem. And if the old project is gone, they should withdraw that H1B and file another one. Okay?
No, in case if they don't withdraw, is it a problem, or they can leave it as it is?
Why should they? If the old project is gone, that H1B should be withdrawn. Now, if you tell me that the old project is still there and I'm still working on it, then you can leave it in play. I don't see any problem, because you have your choice. If project A, project B are both approved with the same employer, you can either go with project B or project A, either one.
So even they can leave it as it is, both of them.
If you are making that answer up, you're not listening to my answer. You are making your answer up.
Oh, sorry.
My answer was
sorry.
Only if the old project is still valid.
okay. If it is not valid, it's good to withdraw the
It should
word
be
one.
withdrawn.
If it is valid,
Absolutely.
oh,
Absolutely.
okay.
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 Good luck.
Okay, thank you.
You're
I
welcome.
appreciate it.
Guys, be careful when I give you an answer. Listen carefully, because you want a certain answer. I understand that, or you have a preconceived notion, but it may not be right. Okay, so you could be misled very easily. Just listen to what I say. Area code 424. Where are you calling from? 424. Oh, I'm sorry, I didn't select you. Area code 424. Where are you calling from?
California?
Yes, sir. Go ahead.
I had a question about stamping for H1. I have like my I-94, present I-94 is expired, but my H1B has been approved for 2 more years.
Okay.
So I want to go for stamping. Would it be a better option to go to India and do a Dropbox, or go to Mexico or Canada?
I think all the consulates are closed right now, aren't they?
No, not right now. I mean, like whenever it's open.
Oh, I mean, I like Dropbox, but also Mexico and Canada are fine, because to go to India all the way for a Dropbox, I don't know. So it's a personal choice.
Okay. But there is no preference which you recommend?
I have no preference.
Like,
I have no preference one way or the other.
Okay.
Okay.
Yeah. Okay. No problem.
Good luck, sir. Okay. Next one is area code 732. I guess that's New Jersey. Go ahead, please, New Jersey.
Yeah, hi Rajiv. This is Swapna here.
हाँ जी मैम.
Yeah. आपका नंबर ना मुझे सोनिया ने दिया, सोनिया गोखलानी.
Oh, of course.
Yeah. So, you know, my mother is a green card holder. She's 86 years old. She left the country last year in June 5th.
अच्छा जी.
And she was booked to come on May 1st. You know, she tries to come back within the 1 year period.
Right.
And so now there are no flights. I mean, there were repatriation flights, but there's no airport staff, nothing. And she's 86 years old. She's wheelchair bound. So the logistics were very difficult to get her to the airport and into the plane.
Right.
So we missed the repatriation flights. I did register her on the STEP program though. And now my question is, if she doesn't enter before June 5th, what happens if she comes in July or August when the commercial flights have started operating? Will she still be allowed entry, or will they give her a tough time at the airport, or how does she go about this now?
Well, first of all,
is there anything I can do to help?
First of all, whenever a green card expires, a new one can always be filed. So you can always start a new green card.
Yeah, but that takes time.
Yes, of course. I'm just listen to the options. Not.
Yeah.
We don't need to.
Okay.
We don't need to discuss the details, but listen to the options first. So always a new green card can be filed. However, the more likely scenario is something called SB1 visa or returning resident permit.
Okay.
Basically, what that involves is, if you just type SB1 visa, Indian consulate, US consulate in India, you should be able to come to a page that gives you the procedure. She has to write as soon as she can, and the consulates are open. She should go back and tell them, I could not travel because I'm in a particularly susceptible age group, and traveling during the COVID times is, of course, not recommended. So I did not want to travel. Now I'm ready to go back. In fact, my flight was booked for May, and I want a returning resident permit. Now remember one thing. She must actually be a resident of USA. If she's just been coming occasionally to USA, they can refuse to give her the SB1. But if she's truly a resident of USA and she had to go back for a trip, that's okay. But if her home is not in USA, she'll have a problem.
No, she comes every year. I mean, just to keep the green card active. Right now, she comes every year for a few months.
They'll not give her an SB1. Because if that issue comes up, they won't give her an SB1. Because the idea of a green card is you live here. If you don't live here, they'll take away your green card anytime they want.
Okay. I understand. So that is not an option. SB1 may not work in her condition.
You can try, but I doubt if you'll get it.
Try. Okay. And there is no directive yet from the immigration or whatever that they may extend this 1 year period due to the COVID-related restrictions?
No, they don't want to make life easy for anyone. Definitely not. Not this administration.
Okay. Not this. Okay. Okay. Thank you so much, Rajiv.
Good
Thank
luck.
you for your time.
Always a pleasure. Bye-bye.
Thank you. Thank you.
Area code 920, Wisconsin. Go ahead, Wisconsin.
Namaste, sir.
Namaste, sir.
I have posted a question earlier, but this is a totally different question.
That's okay. Go ahead.
सुनने में आ रहा है कि the new administration is possibly looking at doing something to H1B and stuff to executive order. So I'm not going to ask you if they are going to do it,
Right.
but I'm asking, can this be done unilaterally through executive order, like suspending the
Okay, your voice is not very clear. Hang on. Slow down. I can barely understand what you're saying. So slow down. Last thing I heard was, I'm not going to ask you what they are going to do. What was the next?
I'm going to ask you, can changing H1B or suspending the H1B program for like 60 days or whatever?
Yeah,
Can that be done through
during
executive order?
emergency, which is where we are right now, the US president has a lot of power. They can pretty much do anything they want. But only during emergency.
But it doesn't necessarily have to go through the Congress and Senate and all.
Well, under the Emergency Powers Act, I think that's what it's called, they have to report back to Congress every X number of days. I don't remember whether it's 30 or 60. But basically, yes, the president can suspend any program they want. But they can't take it away. Okay?
Okay.
Good luck.
Okay, sir.
All right.
Thank you.
Bye-bye. Area code 972. Where are you calling from, 972?
Hi, Rajiv ji. My name is Rohit. I'm calling from Rockville, Maryland.
Hanji, Roji.
So I have a quick question. So my company, let's say if company A has filed for my firm,
Okay.
and it is still pending, or in future if it is audited,
Right.
can I move to a company B on the basis of firm applied by company A and get 1 year H1B extension?
Okay, so
Given that,
hang on one second.
Sorry.
So first of all, let's address that issue. You know that you can get an H1B extension once your labor cert perm has been going on for 1 year, right? So at the first anniversary, if the perm is still pending, you should be able to get an H1B extension through another company.
Oh, okay.
Okay?
Okay. Well, just a quick follow-up question. So let's say, I work for a contracting company,
Right.
and, if some other company gets the contract, but if I'm working at the same job and at the same working location,
You still have to
can other company...
start your green card all over again.
Oh, I see.
Okay?
Okay, got it.
Good luck.
Thank you so
You're
much.
welcome.
Thank you.
You're welcome. Area code 201. I guess that's New York, right? Area code 201?
Yeah.
Hello,
Yeah.
sir.
That's New York. Yeah.
Go ahead.
Yeah.
Go ahead.
Thank you for the call.
Yes, of
So,
course.
I have moved to a different client route right now with my employer, like from client A to client B.
Right.
And my employer is going to file an extension right now with client B. So after filing extension with the client B, my employer can, after filing and getting the receipt notice for the client B, after that, my employer can withdraw the previous extensions, right?
Only
After getting the receipt notice.
if when they file the second amendment with extension, you said, no, let me just hang on one second. So you're right now with client A, and the employer has filed an extension and amendment to go work with client B, right?
No. I changed my client. I'm with the same employer. I just changed my client A to client B.
But you changed without filing an amendment?
No, I'm in the same location. Like my client A and client B are same location.
My question was very simple. Have you or have you not filed an amendment when you changed to client B? And the answer is, I have not filed an amendment. Okay. So, as I discussed several times today.
Because my employer mentioned there is no need to file amendment because of the same location.
I've discussed this several times today, at least twice, that in my view, if the client changes, an amendment should be filed. Okay? Even if it is the same damn building. However, there are lawyers and there are employers who would say, no, that's not required. I don't know if they are right. I think they are wrong. But there's certainly an argument to be made that an amendment should not be necessary. Okay. Now that we are over that point, in my view, amendment should be filed. There are many others who would say it should not be filed. I think they are wrong. They may think I'm wrong. Next question. So we are over this part. Now say, what is the next question?
So, my employer filed the extension with the client A, previous client A already.
Okay.
So I'm going to move to client B right now.
Okay, no, you already moved. You already moved to client B. My question to you now is this. When does your current H-1B expire in hand? When does that expire?
It's September 20.
Okay. So in that case, the previous H-1B can be withdrawn as long as your client B petition is filed before September.
Okay, and you mentioned even when I move to a different client, irrespective of same salary, same MSA, you need to file amendment.
In my opinion, yes. Okay.
So they can file amendment and extension together right now?
Of course.
In that case, with the client B?
Of course. Absolutely.
But they have to file new LCA, I believe, right?
Yes.
For filing new, they have to file new LCA?
Yes.
Okay. So new LCA, new amendment and extension, all the things they need to file.
That is correct. Actually, there are a couple of different viewpoints on this, and I still think mine is the more correct one, but at least you have a defensive position that, hey, your matter of Simeo decision says I don't have to file another H-1B amendment. So I don't know. I mean, I personally think that is an incorrect opinion in this respect. So you should.
Some employer uses the previous LCA and the just because of the same client they use the previous LCA and move on.
Yeah, I think that's the incorrect thing to do. Okay.
Okay, thank you.
You're welcome. Good luck.
Thank you.
From our neighborhood, Virginia. Go ahead. Who is it?
Hello, Rajiv ji. This is Rahul.
Hanji.
I have question related to H4 EAD for my spouse.
Hanji.
I filed my H1B H4 EAD extension on March 13 in expedite case, and my H1B was approved within a week. But H4 EAD has been pending since then. It's 2 months, and I never received any biometric after March 13, for which H4 will be renewed. So my question is there anything could be done, because May 31st is H4 EAD expiring, and that will be her last day on the job. So is there anything which could be done?
Well, first thing you can do is to contact your local congressman's office and see if they can help you expedite the case. You can also Google or search for USCIS expedite criteria and see if she meets any of the criteria. I actually got an expedite on an EAD over the telephone. That was because the lady was working on rural electricity projects, and she was pivotal in many projects. If she had not obtained her EAD extension, many people could be without electricity in the villages. So when you have an emergency, government may be willing to accede to that request. Then I had two cases, one from Pennsylvania, the other one I don't remember. Two different cases where they had been sitting on an EAD for almost 18 months. That was an easy case to win. As soon as we filed, they approved. Another one, they had been sitting for about 9 months. The moment we filed a lawsuit on the H4 EAD delay, they approved the case. So I would say, if you want to be aggressive, you can file a lawsuit after 90 days. But look at their processing times. If it is less than their normal processing time, the court will probably throw us out. But let's say the 90 days passes and the processing time says 4 months or 5 months, then after 5 months, definitely a lawsuit should be filed. But if the processing time says 10 months and we are past 90 days, we should consider a lawsuit, because 10 months is waiting time is just too much. But sometimes courts can take the position, why should one applicant get preference over another just because they filed a lawsuit? Okay. So the idea is, if the normal waiting time is 10 months, you are filing a lawsuit in 4th or 5th month, basically you are kicking somebody else out of the queue to be favorably placed. So that's a difficult decision to make. Of course, when cases have been pending too long, beyond their normal waiting, definitely a lawsuit should be filed. When they are within waiting time, it's a more difficult decision.
Okay, so at least with respect to their processing times, I should wait until then, and then I should take action after that.
That's what I would do. And if you get stuck with period beyond what they think is normal, I would definitely file a lawsuit.
Okay, cool.
Good luck.
Thank you.
Oh, you're welcome. Area code 347. Where are you calling from? 347?
Yeah, Rajiv, I'm calling from New York.
Yes, sir.
My follow-up question is that H1 layoff, so-called furlough. My question is, what are my options if the employer has gone ahead with H1 revocation but has not offered me the ticket?
Well, first of all, you file B1, B2 to protect your status. Then you you do a Google on Wage and Hour Division, Department of Labor Wage and Hour Division. I think the form is called WH4. You basically file a complaint against the employer so that they can get you both your one-way ticket as well as salary for whatever time you were not paid.
Okay.
Good luck.
So this is option once I come to know that they have revoked the visa but have not done the other things, right?
Well, they haven't, even if they revoke, if they haven't informed you, haven't offered you a one-way ticket back, until they do both of those things, you can claim wages.
Okay.
Understood. Good luck.
And I have a small different question.
So you're gonna have to hurry up. I've got 3 more people waiting, so please hurry it along. Don't just wait on the questions.
Yeah, it's regarding it's the CPT. Can a person do CPT?
That's not
remotely for a foreign company.
Easy question to answer. The CPTs are a big problem. Government says one thing, the DSO say another thing. So CPTs are the last choice. If you have no other choice, then go for a CPT. Can it be done remotely? Ask your school. Right now, all schools are doing everything remotely, right?
Yeah, but the DSO is telling that if it is done remotely in US, then it's not possible. But outside US, it can be done.
I would have to I have to go with the word of the DSO. You can also call the SEVIP and ask them the same question. Okay. Good luck.
Okay, thank you.
All right. Area code 240. Where are you calling from?
Hi.
Area code 240.
Hi.
Yeah. Hi. I'm calling from Rockville. So I have a question regarding
my H1B. So I came here as a student. My first H1 was picked up in lottery in 2013.
Okay.
And then I got my I-140 approved in 2016.
Okay.
After that, I changed my employer, and my current employer is in the process of going through my green card.
Okay.
But my previous I-140 is still available. Now the current employer has furloughed me because of the situation.
Okay.
So my first question is, if I lose my H1 status because of this COVID situation, if my employer terminates me, can I get back to H1B after once I lose my status?
You have to maintain
using my previous I-140.
You have to maintain your status. There is no such thing as furloughing an H1B employee. So if I were you, I would be filing a B1, B2 and file a complaint against the employer for back wages. They have to pay you until they, as I told many times before, until they fire you by doing those three things. Until they do that, they are liable to pay you your full salary.
Right. So I'm in the process right now. We are talking. They're probably going to file an amendment this week to correct their mistake. And in case if they don't call me back and terminate me, can I use my previous I-140, the approved one, to get H1 once I lose my status?
Yes. The answer is, first of all, your I-140 is still valid, right? It hasn't been revoked?
Yes.
Has it been?
No, it hasn't.
Has it been approved for 180 days or more?
Yeah, it was in 2016.
That's right. So then you have absolutely no problem. Your right to extend your H1B with any employer based upon this I-140, even if it is revoked, and your right to keep your priority date is forever secure. Okay.
So and if I go on H4 instead of B1, B2,
you can come.
Can I still file for the new H1 using I-140 without leaving the country, or do I have to?
Yes, you can, but it's a very complicated discussion for which I don't have time. The simple answer is yes.
Okay.
But go to our frequently asked questions. I've discussed this question 7 or 8 times in the last few weeks. Okay. So the question is, what do I do?
Thank you so much.
What do I do if my past status is pending, B1, B2 is pending, or H4 is pending, and then I get an H1B job? What should I do? That's the question. And the legal situation of any pending status is the same, whether it's B1, B2 pending, H4 pending, all the same. Okay?
Okay. Sounds good. Thank you so much.
Good luck. This is again, I guess, New York or New Jersey 201.
Yeah, only one more question I have. Can I ask?
Yeah, go ahead.
So, you mentioned for new clients, we need to file LCA whenever go to new client. If the LCA is not approved, then I won't be able to work for the new client.
No, I didn't say that. You heard that, but I did not say that. Look,
No. Just I'm asking
okay.
whether the LCA is not approved.
Look, here is how it works. First of all, if there is a change in client, I think an amendment should be filed. That includes a new LCA, new H1B filing, everything. Okay. But even if you are working for the same client and they move you into the next door building, at the very least, you have to file an LCA notice, even if you don't file an LCA. You have to say that there is an employee working on these premises, H1B, etc. There's a notice for it. So you have to file a notice whenever you change a job location, every time. And that has to be done within 3 days of starting work there. That's the law. Ideally, I always like to do a new LCA. That's just as easy. So I always do a new LCA, or mostly do a new LCA. Now, if you change clients, you should be doing all three. You have to do the LCA, LCA requires posting, and you should be doing an H1B amendment. Okay?
Okay, so just one thing is, like, if LCA is applied, it can be approved or rejected also, right?
It's very rare for an LCA to be rejected. And remember, if it is in the same geographical area, you are actually okay even just posting notice on the premises. So I'm not sure you really need to do an LCA. We usually do, but it's not needed. And I'll also tell you that I don't think you need to worry so much about this, because there is a loophole in the law that makes no sense, and government usually doesn't push back against it. So if you say, well, it's the same geographical area, I shouldn't have to do an amendment, they probably will back off because their own interpretation is so shoddy. It's so dirty. It's not a clean explanation. Okay. But if it was a smart lawyer, they would raise an objection.
Oh, okay. It depends upon the perspective.
Yeah, but I know this that they have not been pushing on this issue. I think it's something you should be prepared for, but it's not the end of the world. You'll be fine. Okay.
Okay, so yeah, we can use the previous LCA and file the new extension with the new client also.
You can, but you have to do a posting in the new premises. That's non-discretionary. That has to be done. Okay.
Yeah, posting the previous LCA and then file LCA with the new extension. Okay.
Well, if you move from location X to Y, I can use the LCA of location X, but I have to post notice again on location Y. I don't have to do an LCA again for Y, but I usually do it. Okay.
No, that's just what I changed the client and I'm going to my employer. That's what my understanding is. They can use the previous LCA for the client A and file a new extension for the client B.
No,
they can use the
you still haven't heard me completely. You have to file a notice of posting in the new location. I don't give a damn whether you do an LCA or not, but the law does require physical posting of a notice in the new premises. That's the law.
The posting the notice in the notice board. Kind of
that is correct. Okay. Absolutely. Good luck, sir. I gotta go. Okay, guys. I think we are done with all the questions, and I'm really tired. I wish I was able to spend more time with you guys, but it's a lot of talking. So I'll see you again in 2 weeks. Hang in there, guys. We shall get through this. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.